right, so we're going to go ahead and get started. So thanks everyone for joining us today. I'm Sharon Campo. I'm here at Legal Services of Long Island, formerly known as NASA Suffolk Law Services. I am a supervising attorney here in our Suffolk office. And today, our Legal Support Center for Advocates will be having Kirsten Bartolotta speaking to us about understanding the 17A guardianship option for parents. Kirsten is our Suffolk County Pro Bono Project coordinator. So just a little housekeeping. Please make sure that you keep your microphone muted. That way we don't have any background noise. If you do have any questions, you can put them in the chat. I do have on there, raise your hand, but please ignore that. Just put the questions in the chat. What we'll be doing with questions is we will address them at the end of the presentation. So you can put them in the chat throughout as you think of them, and then we'll address them at the end. We're going to have at least one or two polls just to keep things lively. And then at the end of the presentation, we have a survey. If you don't mind just filling that out quickly, we really appreciate it. So for those of you who do not know, we are now Legal Services of Long Island, formerly NASA Suffolk Law Services. So we've changed our name in September to reflect more of who we are and what we do. So just keep your eyes open for our new name everywhere, website. So just keep that in mind when you're referring folks to us and looking up our information. So if you're unfamiliar with us, we are Long Island's largest civil legal services provider. We handle over 6,000 legal cases every year. All of our services are free to those who are income eligible or eligible in some other way. You do have to live on Long Island. We provide direct representation, phone consultations, brief services, referrals. We have offices in Hempstead, Riverhead, and Islandia. And our case handling staff do include attorneys, paralegals, and social workers. We do also have partnerships with community agencies such as Empire Justice or Corazon or other Brighter Tomorrows or other organizations as well. We have 3 different offices. So those are their different addresses and phone numbers. If you're going to be making a referral for a client, please have them call those phone numbers so they can see if they are, so they can be screened for eligibility. We have about 20 different programs throughout Long Island. We have a domestic violence and our child support defense project in Suffolk County. We have multiple disability and health related units, including our mental health law project, our education disability rights project, our HIV unit. We also have many different housing units, including foreclosure defense, our civil unit, which is essentially eviction prevention, and then other areas which may be specific by the area of law or specific to our clients. So for example, we have a veterans rights project that serves veterans. We have our consumer debt project in both counties. We have a senior citizen project in Nassau County. Any of the descriptions of our different programs are on our website. So please feel free to call, or excuse me, feel free to take a look at our website so you can see the different descriptions. And our Legal Support Center for Advocates is a service specifically for advocates, including folks who work for nonprofits, church organizations, could be a government agency or a hospital. So anyone who has clients who are in need of our services, and they're curious, maybe they're not sure whether it's the type of case we would take. So please feel free, if you're an advocate, to reach out to us and to see if your client is eligible, or if you have like a legal question, we can try to guide you in the right direction. But just remember, this service is for advocates only. We are not case handlers. Any clients do need to be directed to our receptionist, which is the main numbers. We also do host community trainings like we are doing right now. Last week we had our legal resource fair in Brentwood. So we do have different presentations that we give to the community as well. And we publish newsletters and we email out our advocacy tips every month as well. So just really briefly, we're going to do a quick little poll. So let me bring it up. The first question is going to be, what type of advocate are you? So if you just could take a moment just to answer that, really appreciate it. Okay, a few more seconds. Okay, so let's see who we have with us today. So we have a bunch of attorneys with us today, some nonprofit employees, some social workers. So thanks so much for joining us today. Really appreciate you being here with us. And then our next question, let me just get back to the other question, will be, have you ever called the legal support center for advocates? So just really briefly, we just answer that question. Okay, great. Thanks so much. I'm going to share the results. So we have one person who is Kathy Lucidi on speed dial. So welcome back. We have some people who've called us once in a while. So once again, welcome back. And then we have a lot of people who never knew about our service, the Legal Support Center for Advocates. So welcome. And please, if you are an advocate, feel free to use our service. It's free. And join all of our presentations. Okay. So we definitely visit our website, legalservicesli.org. You can sign up for our legal lessons or trainings, take a look at when our future trainings are, any self-help resources we have on there, and any other events we have going on. Okay, and just a quick note, any information we share with you today is legal information. We try to keep it as up to date as possible, but any information that is contained in herein is not legal advice. Legal advice does depend upon the specific facts of each situation. So, and our materials, of course, cannot replace the advice of competent legal counsel. All right, and with that, I'm going to pass it along to Kirsten.
Okay, and I just want to say, my internet has been freezing a lot. So Sharon, I'm going to keep my cell phone here, and I'm going to watch and see if anything, if something is not coming through. But I'm going to continue forward, and we'll see how it goes. With answering questions, we might have a delay because it's stopping every few minutes. But otherwise, I think we're good. So I'm Kirsten Bartolotta. I'm the Suffolk Pro Bono Coordinator at Legal Services of Long Island, and I'm so happy to be here with everybody. Thank you for taking some time to come. And for the person who put a question in the chat, it's okay, you're advocating for your son. And we will give you a process to check in with us and sign up for an intake to see if we can help you in the future. So there'll be some instruction on that at the end. So today, for advocates, we were thinking it would be helpful for advocates and community members to know a little bit about 17A guardianship so that you can provide resources and services, and also maybe even identify a situation where a client might need information about the 17A process. So we thought this would be a good opportunity to talk about both what we're going to do, explore the options of 17A guardianships that are available to parents of disabled individuals aged 18 and older, or those approaching adulthood, in regard to these decisions that individuals need to make in regard to their health and welfare and finances. And also we're going to talk a little bit about the specific requirements of 17A guardianship petitions so that you have an idea of what parents are going to go through or may be going through, and you can provide some support in knowing some of what they are experiencing. So we're going to have questions at the end of the presentation through the chat. I think Sharon's going to help me. Hopefully that computer issue won't cause any problems. But I do want to qualify it by saying that 17A is a very broad scope guardianship. which means the courts have a lot to look at and determine, and it's best interest of the individual in the decision-making process. So each case is handled very differently. So it's not always easy to answer questions for specific clients because we don't know what the court will be looking at or determining that they need to do. Each case is so different, but we will answer any questions that we can, and also we'll give you some a way to take next steps if you have a question we cannot answer. Okay, next slide, please. So why does a parent or caretaker need a 17A guardianship or other types of decision-making assistance? Because in New York, we know when children are under 18, whether they're disabled or not, parents have a right to make decisions for their children. But once they turn 18, New York state law indicates that a person is competent, a competent adult to manage their everyday lives, and their parents don't have any ability to help them if they have a child that is disabled. So this is the reason we're starting to talk about the 17A process and other options. Next slide, please. So what are the options for parents or caretakers that have a child who is developmentally disabled or intellectually disabled and turning 18? So two documents that can sometimes be used is a power of attorney and a healthcare proxy. And what that is a power of attorney is kind of like a contract that a person can give power to another person, maybe their parent, to help them in making decisions. Healthcare proxy is similar. They're appointing a person they trust in relation to their medical decisions. 2 points to note with power of attorney and healthcare proxy is that the person must have capacity at the time of the creation and give consent. And that's the reason we can't use it consistently with these kind of cases. And Article 81 is a guardianship. It's very tailored to the person, and it's often used when people lose capacity. You'll see it often with people that are elderly, and somebody comes in and petitions the court because they see this loss of capacity. It's a complex, and it can be a costly process. And it is different than 17A because it can be tailored to the need of the person versus 17As, guardianships, which are very broad applications. So it could be a little less stringent in the application for the person. But usually the person has, when we talk about intellectual and developmental disabilities, they would have to have a higher function ability to consider an Article 81. So that's when we fall into, and what we see often is the 17A guardianship. It's a broad application. It is generally for life. It's pushed and driven through a medical diagnosis and supported by doctors' reports. There's usually indications and information that the condition will not improve. Often people are born with the condition when we see 17As. And it's been determined that the individual is deemed incapable of managing their affairs. And so that's how the 17A guardianship is usually applied. It's important to note that the 17A guardianship, I've said it twice now, is very restrictive. It is broad strokes in saying that, let's just say for this application, a parent has the ability to manage. It's almost like the parent of a 16-year-old just moves over to the person who is now 19 and still has all those abilities to manage that person's decisions. So that's why the courts are very careful in the analysis of using and applying this to families and to individuals, because it's taking the rights away from somebody. And so that's why the best interest of the disabled individual is what they're paying attention to. Next slide, please. Just so you know, you were frozen. That's why that was so long. Sorry, everybody.
I was wondering.
Yep. And you see that it's just because I'm waiting and you guys are all like frozen. Okay. How do parents help how to help parents with developmentally or intellectually disabled children turning 18 or 18 plus who are thinking about these options. So the first thing I just want to mention, you can see these numbers here. So this is applicable when the person turns 18, but you don't have to, that's not your only time to apply for it. A person can apply for a 17A guardianship after the disabled person turns 18. They could be 19, they could be 20, they could be older. And also you can start the application process before they turn 18. So there is that flexibility. Often what we find is a doctor will say to a 16-year-old, a parent of a 16-year-old or a 17-year-old, you need to think about a 17A. And then that's when we usually talk to people that are thinking about it. But we do have people come to us later on as well, because they never knew or they never had any problems with the decisions that they were making in relation to the outside world. So parents have a couple of options when they're thinking, and caretakers. They can call a private attorney and get a consultation to explore what options will be best based on the circumstances of their child. The attorney can answer some questions specifically about their case. There's a lot of attorneys on Long Island that do 17A guardianships. They're very knowledgeable. And then they would provide their cost, their fees for the service of the petition preparation. The second option is parents can consider doing it themselves. And I put the link here, and we'll be giving out this information by email, that you can go into the New York State webpage, and there is so much information on 17A guardianship. And there is this belief and approach that people can do it on their own, and some can. So that is one way. And then the third is going to maybe a nonprofit organization that can, if the client is eligible, they can assist in some way. And there was another nonprofit on Long Island that is full capacity. They are not helping at this time. They're hoping to come back and start again. But we, Legal Services of Long Island, are working on a project to be able to help with that. So I just want to, next slide, and we'll talk about what we are doing. And then we're going to send this information out. So we're going to have a free upcoming legal clinic. It's going to be, this is for parents and caretakers. It's advice, counsel, and information on the process of 17A guardianship. And we will do, and this information is here, we'll do an intake with the clients by a certain date. If they are eligible based on our income and asset requirements, they will be invited to meet with an attorney to talk about their case on the 17A process. They'll be able to get real specific information in regard to their situation. And then from there, they can make their decisions as to what are next steps for them. And we will try to take some, based on volunteer attorneys, we will, and qualifications, we may be able to take some of these cases to the next level in completing the preparation. All right, so we're going to have this slide up, and we're going to send this flyer out for everybody. So you will have it. You want to go to the next slide, please? Frozen. Okay, what is a 17A guardianship? Guardian, so a 17A guardian is someone, it can be a person or a corporation, who is appointed by a surrogate court to help protect the interests of intellectually and developmentally disabled adult, and make decisions for them when they are unable to do so for themselves. Now, this list here is not all inclusive. This is what New York State has listed on their website, just examples. But of course, there are many other situations or conditions that would qualify for the 17A guardianship. Next slide, please. So there's two types of guardianships under 17A. There's the guardianship of person and the guardianship of property. And it's exactly what it sounds like. Guardianship of a person is when the proposed guardian manages the disabled party's personal well-being, their health, their safety, and their welfare. Guardianship of property is when they manage just the property of the disabled person, and that's limited. It could be an inheritance, it could be real property, and it could be a settlement. And then you can also apply to do both. So you have those combinations. Next slide, please. When a parent decides that a 17A guardianship is appropriate. So if a parent or a caretaker is thinking this is something they want to do, we went over, there's numerous ways to start the process. We want to give you a little feedback as to the process so that, again, you have some awareness and information about what clients either are going through or will be going through, because they may be talking to you about it also, but also to help, you can even maybe help them sometimes to gather information. So we wanted to talk a little bit about the process. And we think that also people understanding the transparency of process really calms people down, and that's understandable. We want people to, it's such a stressful situation. So being able to understand what next steps are helps people. So the petition is filed in surrogate court in the county where the child lives. It can be done when the disabled individual is under 18, 18, or older than 18. It should be close to the 18 time period, but it can be before. The New York court system has a lot of information, like I stated, for parents and proposed guardians who may be interested in learning more about the process. And some people find it very helpful and some people find it very overwhelming. We have a lot of clients that come to us that tried it on their own. Some are successful and some say, I did it 2 years ago and it's sitting on a desk and I can't handle it. And there's some people that have gone to attorneys and they've just backed out of it because of some of the steps. The timing have been so difficult for them that they haven't been able to complete it. So we do hear that, and that is something that advocates might hear as well as they're going through the process. Next slide, please. So what else do we need to know? Below are some of the considerations that people need to think about when they are going to start the process. And one of the first steps is to think about the proposed guardian or co-guardians. They have to know who is going to be the guardian. Am I going to share this with a co-guardian who's going to have equal rights at the same time? The guardians must be legal residents or legal citizens of the US, and they must be 18 or older. Who will be standby guardians and who will be alternate guardians? So again, we have to think, the parents or the caretakers have to think, if I'm the guardian and I lose capacity or I die, who do I trust to step in for me? And then we have an alternate below that. So there's a lot of people that can be listed. There's complications if you list a lot of people. It's not just a safety net where you just keep listing, because there's a lot to go through in relation to this work. But you do want to think about that. And we want parents to deeply think about who they want if something happens to them. Parents, siblings, and half-siblings, spouses of the disabled individual, or adult children of the disabled individuals who are not asking the court to be a guardian or a standby guardian are called interested parties. And they need to sign consents, which are called waivers, to allow for the proposed guardian. So that is all those other people that are going to be informed by the court, unless they sign it, unless they go and sign that waiver, they're going to be told, this person's going to become the guardian of the disabled person. Are you okay with that? One of the things we hear often is, well, the father or the mother has disappeared and they haven't given me any custody and I don't want them to be informed or know what's going on here. And the answer is they're going to have to. So there's no easy way out in relation to consent, but it's not a barrier. If there's a problem reaching them, if they're missing in action, there are ways for the court to address, to help us to do what we need to get the consent or to feel that they have enough notification that we can move forward. So it's not a complete barrier. It just makes it additional steps. Next slide, please. Continuing on need to know, what kind of proof does a parent or proposed guardian need to submit as to why the child needs a 17A guardian appointed? So this does vary. There is a structured answer, but there's also a little, it does vary within counties also. So we can talk about Suffolk here. And that would be, you have to file a petition with accompanying paperwork, includes a birth certificate. There is a filing fee of $20, which can be waived. And one of the most important parts is the certifications. And that is where the doctors or the licensed psychologists tell the court through a affidavit or affirmation that this is needed, that there is a medical issue, there is a diagnosis, this is what it is, these are the tests, and I'm saying that this person needs a guardian. This is one of the most challenging parts and one of the biggest delays in relation to the process, because the paperwork is very specific and the doctors and licensed psychologists have to do it in a certain way for them to accept it, and it has to be timely. That's another issue. There's there's a time period from when the child is seen and when the petition is filed that needs to be done within a year. And believe it or not, people go over the year all the time because of the complications. But with good support, we can help doctors and licensed psychologists to think about this and know, we don't want to tell them what to do, but we want to tell them how to prepare it correctly because the court is so specific with it. And as you see here, it's 2 medical doctors or 1 MD and 1 licensed psychologist. And there must be 1 physician who is familiar with or has professional knowledge of the care and treatment of a person they are making the certification for. And then any medical reports that the doctor refers to in these documents have to be submitted as well. So you can see it's specific and it's very important because this is what the court is going to lean on as they start to make their determinations. Next slide. So parents and proposed guardians must sign the petition and acknowledge. So this is something we find that parents get or people that want to be guardians get very concerned about. And why we want to make sure people understand this. When somebody is requesting to be the proposed guardian, they have to tell the court in a document whether they or anyone in the household of the disabled person has been a subject to a report for child abuse. They have to let the court know if they've been convicted of a certain offense of law, not traffic offenses or youthful offenders. And they have to let the court know if there's any pending criminal charges. But what I want everyone to know is that if this was to come up, it does not mean that automatically this person can't be a guardian. It's just another step because sometimes CPS reports are unfounded, which is going to be submitted and supported and maybe checked out, but that person can still go forward as a guardian. So these are some of the issues that have to be sworn to in the documents. Next slide, please. Okay, the petition and accompanying paperwork is extensive and specific. After the petition is filed with the surrogate's court, everyone who lives in the household of the disabled person who is 18 or older must be fingerprinted. This doesn't happen until the court says, go do it. They give you instructions, but that will have to happen. Everyone in the household of the disabled person who is 18 and older must inform the court as to their addresses going back 28 years, including month and year. You can see it's stating the obvious. These people are living with the person and they want to make sure that it's a safe environment. And then service. When the court gives you permission to move forward, the court will instruct the proposed guardian to serve interested parties who may not have consented. They give instructions to you on how to serve. And many people know from watching like Law and Order about service, or maybe you have experience, that often it has to be an uninterested party. Sometimes you have to pay for a person to do service. You see them like throw it at someone's feet at the airport. For this process, it's a more friendly process. The court allows in Suffolk County for the guardian to serve an interested party. So they can serve their son. Even if they're having problems with their son's not going to sign, he's a sibling, and she sees him on Sunday to talk to him, she can serve him. So they give great instructions on that. Yeah. After this is done, and the court will then most likely set a hearing, and they will most likely request that the disabled person is present. It's not required, but it must be supported, meaning the doctors and the parents say, it's not a good situation, he or she can't come, and then the person wouldn't come. I've seen that before. But if they can come, they should come. It helps in the process. The proposed guardian does not need an attorney to go to a hearing, so they can do this on their own. Again, it's more of a friendly process. They want people to be able to do this if they can't get an attorney. Sometimes a guardian ad litem is appointed. So that is an attorney that the court appoints to look into this case. Two things we want to mention with that. One, because we had a client say to us this, and it's understandable. They said, is that now my son's guardian while this process is going on? Absolutely not. A guardian ad litem is investigating or checking circumstances that are there that the court wants to learn more about, and they are protecting the best interest of the disabled person. And a good example of that would be, let's say there's a CPS report for an unfounded report. It's in the petition. They might assign a guardian ad litem to do some work on that to make sure what happened and how it was unfounded. Certain types of disabilities also, a guardian could be appointed. And the standard is the best interest of the individual. The surrogate court process, they're very helpful at the Suffolk County level. They will hand back petitions to proposed guardians with notes and instructions on how to correct. Because if you don't check one box, it's going to be sent back. And there's a lot of boxes to check. So they are very good at supporting the families that are doing these petitions. The process can be long, it can be tedious, but it can be completed if it's the right option. Understand, some people, it's right away, it's clean. And then in other situations, it can drag on and it can be more complicated. Next slide, please. Okay, so this is again our flyer. I just wanted to mention how this will work. And again, you will get a copy of this. We would ask that clients who are interested in the advice and counsel clinic would call our number, which is there, and they will then be screened for eligibility. And then if they are eligible based on our guidelines, in December, we will give the date, and it's going to be at our Islandia office. They will come and they will get an opportunity to meet with an attorney and talk about their case. And so we'll get that out to you as soon as we can. So I don't know if we have any questions.
Hi, Kirsten. So I'm going to go over some of the questions here. So some of these are very specific. So, we may not be able to answer them today, but we will work our best to get you an answer afterwards. Because today we're mostly focusing on, the advanced planning clinic and what's appropriate for getting the 17A guardianship. So just the first one, I think you already addressed, Kirsten, but want to remove 17A guardianship for my 32-year-old disabled son. Can this be done?
It can be terminated and modified. There is a process. You would have to go to surrogate's court to find out that process, and it's intensive. But it absolutely 17As can be modified, terminated, and altered through surrogate court. And you can go to the court to ask them what next steps would be in relation for you if you wanted to get involved in that.
Thank you. Okay. Where can families find a psychologist to complete the GMD-2A affidavit as the second source, not including school psychologists because many are not licensed and are not eligible?
So that's correct. They have to be licensed psychologists to do this. And it's just a licensed psychologist who is able and willing to see your son or daughter to fill out that form. You can speak to your neurologist or your family practitioner and see if they would recommend somebody. Many licensed psychologists are very familiar with the 17A. And you can even call a licensed psychologist that you're thinking about going to see and say, are you familiar with the 17A? Because that's what I'm trying to get paperwork on. So we don't have a list, and we think it would be good to do your due diligence in finding a psychologist that would, honestly and carefully look at your son or daughter and do the evaluation. Again, good catch there. It is a licensed psychologist to be able to do that.
Awesome. And then will this recording be available? And yes, it will be available. We always put our recordings on our YouTube channel, and also, it's actually on our website, which directs to our YouTube channel. But as soon as we have this ready, I will send it out to everybody as well, so you can have the link. If a 17A guardianship is granted, would they still be eligible for SSI/SSD and services?
Yes. Will not affect their income.
Okay. I think that's one of the reasons why to get a 17A guardianship is so you can help out with, help the child or the child with getting the services. Is there legal, so I answered this, but I'll just go over it again. Is there legal services affiliated with an office in Queens? So we are only serve Long Island. There's many, many legal service providers in Queens. I couldn't tell you if they did a 17A guardianship or not, because there's so many. But the best way to find out is just to, if you're looking for free legal services, just Google free legal services in Queens. Or you can call the local Queens Bar Association, and they might be able to direct you, because they do have relationships with the local legal services providers. Okay, does the other parent have to sign off on the guardianship to the main parent?
So yes, let's say there's two parents, and one parent is the one that's saying, I want to be the guardian and I don't want you to be a co-guardian or anything else. The other parent would have to sign the consent or the waiver in regard to this. And again, if they were not around, there would be a process just to make sure that they're aware and have the right to be heard in relation to the guardianship.
Awesome. Okay, how far in advance of my child's 18th birthday can I file for guardianship? And then second part, also, how long does the process take once documents are sent to court?
So it shouldn't be done way in advance because of timeliness of documents, including medical. So we're seeing 16 and 17-year-old is probably the prime time to start working on the paperwork. The second question varies drastically based on how simple the court thinks the case is and how complex the court thinks it is. So it could take 6 months. I have heard from an attorney they're in the 2-year point, and there's a guardian ad litem assigned, and there's interviewing taking place. So it really ranges based on the circumstances of the case.
If I am appointed as guardian of my son and his property, and something happened to me, will that guardianship automatically transfer to my husband, who is a stepfather of my son?
Okay, so what happens is what you have to put in the guardianship is you have to put co-guardians. You don't have to put co-guardians, but you can, or you need to put standbys. And that's how it moves through the system, regardless of the relationship. So if you have the standby guardian in, and something was to happen to you, then your standby, who has to be knowledgeable and understand the process, has to go running to the court to say, I'm a standby, please put me in as the permanent guardian, because there's decisions to be made. So that's the process. If there was no standby, then probably somebody would have to go petition the court to come into place. There is nothing that's automatically done.
Okay. Are there services available in Nassau County? So we do have services available in general for depending on the program, for legal services of Long Island and Nassau County. Kirsten, do you know if the Volunteer Lawyers Project provides similar services for 17A guardianships? I
don't know.
So I will have to get that. I don't remember off the top of my head. So Jennifer, transfer, I will have to get back to you on that one. Does the psychologist affidavit have to be notarized?
So yes, so that's the, in the notes, we had an affirmation or an affidavit, and that is based on doctor or licensed psychologist. So doctors do not have to be notarized, but licensed psychologists have to be notarized. And there are two separate forms based on their title.
Okay. Can a neuropsychologist report count as a medical certification?
So I don't know. I don't know if he or she is an MD. Absolutely. If they're a licensed psychologist in that area, then I would say yes. So we would have to look at, again, it's that MD, doctor, or licensed psychologist, which is very easy to determine and find out, even calling their office.
Mm-hmm. Yeah, that's probably the best bet, is call their office. When you talk about financial eligibility for your services, do you consider the finances of the adult who is 22, receives SSI, but lives with parents?
If you have questions, I think, about eligibility, it would be great for you to call us, so we can do the analysis of what, you know, your assets and income. I think, I'm not sure, I don't know if you want to add on to that. But we have certain guidelines that we have to go through to determine.
Yes, yes.
Who's
The best way
eligible.
is just to call and we can evaluate you. And then this is also about eligibility. I live in Manhattan, but my son attends a specialized school on Long Island. Would these resources apply to him or only to people who live on Long Island? So our grant, so, you know, we get grant specific. We can only assist folks who are living on Long Island. And most likely, I would assume that any petition would have to be filed where he resides. Is that correct, Kirsten?
Yes, yes.
Yeah, so we wouldn't be able to send an attorney to Manhattan because our pro bono attorneys are in Nassau and Suffolk. School psychologist here. We keep lists of, okay, so this is from a school psychologist who says, we keep lists for families of local licensed psychologists who can complete the forms. Reach out to your building psychologist and they should have referrals. Great, thank you so much for that tip. Good to know, for sure. You can see, so another person wrote, you can see if the psychologist in your child's school district can complete this. So once again, check with the school. I have had several addresses. Do I need to be accurate with month and year of my various residences? I don't know. Do you know that, Kirsten?
Yeah, you just froze. I'm sorry. I was just waiting.
Oh, okay.
I was breathing through it. Yes, some attorneys have done paperwork, just so from my experience of talking to people, because we do it with month and year. We recommend that. The court says that. I'm not saying that the court would kick it back for that, but they are very strongly worded documents. And from our experience, you should put the best that you can. Sometimes you got to Google yourself. Do your homework, put it in, and if you can't figure it out exactly, do the best you can.
Okay, great. Edna, I'm not really sure what your question or comment is. And then number 2, once the 17A is in place, will they go off of the parent's income like they do when they are under 18 when it comes to SSI/SSD and services?
Yeah, I believe that they're treated as adults in relation to income, but their SSI and SSD is not affected by the guardianship. It's completely separate.
Yeah. If I have full sole legal custody, does the other parent still need to sign up on it? I think we already answered that question, which is yes, right?
Yes.
Regarding medical reports, how old should documentation be within the year of applying for guardianship? Is that?
Yes, I always get this confused. I have to think it out. It has to be signed by the doctor within a year of filing the petition.
Okay, great. Are there discounted legal services available for Nassau County residents? We only provide we are not we're not allowed to give out referrals except for the Bar Association. So you would have to contact the Nassau County Bar Association. If you have a neglect indication finding, can you still be granted guardianship?
Because of the specificness of that, we wouldn't be able to answer it. I would not say you could not, but I would say there's going to be a very long process and hearing in relation to the report in the determinations if it goes forward.
Awesome. Thank you so much, Kirsten. If anyone else has any questions that come up afterwards, you can feel free to email me. You should have gotten an email from me this morning with a copy of the presentation, and I will pass along the question. So we do have some upcoming presentations. Tomorrow is our legal steps after domestic violence incident, which will go over steps for filing an order of protection and also child custody. Next month in November, we're going to have our education disability rights presentation, November 12th. I will be sending out the link to sign up for that soon. And then I just planned a presentation for December, the emergency housing training on December 6th. So once again, once I get that link ready, I'll send that out. And if you have any questions, you can also email Kirsten at suffolkprobono@legalservicesli.org. So thank you so much, everyone. And I hope you enjoy the rest of your day. Happy Halloween on Thursday. And we'll see you all again soon.